And that gets to Judge Flynn's comment, there needs to be some proportionality. At some point you say, I'm not going back 30 years to retrieve documents. Those documents could tangentially be relevant, but they're not valuable for purposes of litigation.
So we polled this audience. We polled the audience and we said, how many have more than 100 holds? 25% of you, by the way, responded that you have 100 or more holds. If you are a large organization of 25,000 or more employees, then we were at 53%. In addition, after saying how many holds do you have, that's 100 or more, we asked the audience, we said, if you have holds, what percentage, do you have a hold that's very broad in nature, that's covering a whole business line, that's covering some broad set of information? 79% of the audience came back saying that they're preserving based on a very broad hold. And from a records management perspective, what I see is where we start applying these holds either to an entire business unit or to an entire subject matter, not looking at the relevancy to the issues of the particular case. We're just doing things much more broadly. And so that's really what I wanted to talk about, because when we go to counsel, not the Ken Withers of the world, that's where we get the direction to be very broad in nature.
And here is the essential confusion. It's a confusion between retention and preservation. Retention is going to be based on broad categories of information that you need for a business purpose. You're going to make business decisions. You're going to carry them out on a routine basis. Preservation is not only a tail wagging the dog, it's the flea on the tail wagging the dog. Preservation has to be viewed from a very different point of view. You don't start out looking at preservation in terms of broad categories of documents or business units, things of that sort. You'd have to start looking at preservation from the point of view of relevance. And to repeat what Judge Shaffer said, that means a reasonable determination of what the claims and defenses are likely to be in this anticipated litigation. Granted, that's kind of loose, but it's much narrower than saying, we have an employment discrimination claim, we're going to lock down all the HR files. No, you have an employment discrimination claim, we're going to, maybe I'll call on outside counsel, and I'll say, here is the situation. Can you define for us what you think are going to be the causes of action and our defenses? What is going to be at issue factually in the case that's going to require discovery? And then we'll say, well, what are the most likely sources of that particular information? Then I'll go to my technical people, either in-house litigation support or IT, to sequester that information. But it's not going to be a whole broad category. And the problem, I think, is that people have been confusing the strategy of developing retention policies, which deals with broad categories of documents, and preservation, litigation holds, which have to start from the facts of the case, the potential claims and defenses, and particularly what is going to likely to be called on in discovery.
And John, putting on your hat as the technical expert for electronic discovery, can you talk about the preserve in place versus collection, as a mechanism for preserving? Can you kind of talk through some of those issues and what you see as a best practice?